If you have any questions or?
I do. Are you going to come to trial and say there wasn't hydrazine in the water? Calling pages 2 through 29, case 831543, Hunwardsen versus Affinity Lifestyles et al. So let's walk through. Start with counsels for plaintiffs, please.
Will Kemp for plaintiffs, with the exception of Sosa.
Good morning, Your Honor. Teddy Parker, we have plaintiff Sosa.
And Eric Pepperman for plaintiffs with the exception of Sosa.
Okay, appreciate it. On behalf of Affinity Lifestyles, DBA Real Water, go ahead, please.
Good morning, Your Honor. Joel Odou on behalf of AffinityLifestyles.com Inc., Real Water Inc., and Real Water Gold Coast. I have on video Matthew Kaufman, who's seeking admission pro hac vice.
Okay.
Good morning, Eric Freeman for Affinity Lifestyles and Real Water.
Okay. Hannah, instruments, please.
Morning, Your Honor. Chad Fears on behalf of NSF Scientific Instrument Development, Inc. and International, and have Ryan.
Ryan Flanagan, same parties.
Right. We're not going to be able to hear you all, just FYI, when you're back in the gallery. Are you going to be speaking anymore, or is that it?
If I need to speak more, I'll move up to the
Okay. Yeah, we need to probably so we can get appearances. Okay. Milwaukee Instruments, please.
Milwaukee Instruments, Elizabeth Lowell on behalf of them, bar number 8551. Is that recorded?
Did you hear that okay? Yes, thank you. Okay. Anybody else on Milwaukee?
I'm sorry, Your Honor.
Anybody else on Milwaukee or just yourself?
Just my.
Okay, just to make sure, because we got everyone on Hannah, we got everyone on Real Water, we got everyone on Milwaukee. Okay, that means I go next to ETT, DBA, Terrible Herbst.
Good morning, Valerie Rojas and Jan Tomasic for Terrible Herbst.
Okie doke. Now let's go to United Foods Entities.
Morning, Your Honor. Lew Brandon, Davis Burlock, also Jim Neal, here on behalf of United Natural Teams West and WFM Southern Nevada Inc. Also, Dan Olsenberg is here. Again, I do not believe he's entered appearance in this case.
So you're just observing Mr. Polsenberg, is that correct?
Yes, Your Honor, and Abe Smith is here just observing as well.
Okay. On behalf of NSF.
Good morning, Your Honor. Jonathan Fountain, and we've got Patrick McCarthy on Blue Jeans.
Okay. Who have we? Real Water, Tennessee, please.
Good morning, Your Honor. Jim Cavanaugh and Robert Schumacher on behalf of Real Water of Tennessee, LLC.
Okay. I have a lot more boxes, and I've gone through everyone that I was told from last week was still in the case or subject to a motion for good faith today. Is there anybody else who's not made an appearance here in court? Looks like we've got you all. Anybody else just observing? Okay. So
good morning, Your Honor. Daniela,
LaBounty. Finishing here in court.
Defendant Costco.
Excuse me a moment. Can I finish here in court, please? Then I'll go remotely. Thank you so very much. No worries. Okay. Remotely. Go ahead, counsel for Costco. Thank you.
Sorry. Daniela LaBounty on behalf of defendant Costco.
Okay. Do any of the other blue boxes want to say anything or make any appearances or just observing? You're more than welcome to observe. It is a public courtroom. Do remember there was a media request with regards to this that was granted for all hearings. And so remember that they are allowed to record because they have a media request. Nobody else can record. You're, of course, more than welcome to observe and do whatever is appropriate in accordance with the rules. Okay, that being said, we've got a lot on the plate for today, but what we're going to start with is the quicker things. First, we're going to start with a couple of motions for good faith settlement. I was going to do first United Natural Foods and WFM of Southern Nevada. First, your motion to seal and redact, and then your motion for determination of good faith settlement. On your motion to seal and redact, the court does have a question, because I did not see that you filed both a redacted and an unredacted version. I only saw that you filed document 519 on 11/9, and in that you did request certain pages of the underlying motion for good faith, including, I think it was pages 7 and a couple of the other pages, 7, 9, 16, 17, and 18, I believe. but I did not see that you filed a document which would have had those sealed. So the court's question is going to be, under Supreme Court Rule 3, not only do I need to evaluate it, but this court can't go back into a document and redact portions. Normally the process would be you file both a redacted version as well as a unredacted version, and the unredacted version would get temporarily sealed pursuant to pending court approval. So can you just clarify if you did file one? I was looking through the 600 plus entries. I didn't see it. So if I missed it, let me know.
Yeah, you're right, Your Honor. We didn't do that, but we could provide a redacted version.
Okay, so you went through your analysis, Supreme Court Rule 3, the court was inclined to grant the redaction subject to the fact that you need to file a new pleading that actually has those redactions in it, so that it would be for public record to see the redacted version filed. Because, like I said, the court can't go in and parse into a document and go in and redact it.
Yeah, that's fair, Your Honor. It's just simply the amount of the settlement, and I could submit that to the court, that redacted version, those couple lines.
This motion was unopposed. The court did its analysis under Supreme Court Rule 3, but since I have you all here, does anybody wish to address the motion to seal and redact by the United Natural Food Entities? If so, please let the court know. Anybody here in court? No? Okay. Anybody remotely? Pausing for a second? No. Okay. So now let's go to your... So the court finds under Supreme Court Rule 3, subject to what the court just said as far as protocol of needing a redacted version in the public records, that needs to get done. The court's going to grant the motion. Please provide a proposed order in accordance with DCR 7.21 within 14 days to the DC 31 inbox. So now let's go to your motion for good faith settlement, which is on OST, which was document 506. Other than you wish to say amount set forth in the redacted portion, do you want to walk through 17125, doctors, MGM factors, all good possible?
Sure, Judge. There was an offer extended, an offer of judgment. We accepted that. I think it's a fair offer. There's really no issue regarding policy information or financial condition of the defendants. There's no collusion, fraud, or any type of tortious conduct in settling this. I also do not see any opposition to this. Based upon that, I'd ask the court to grant our motion.
Okay. Was there any split at all between or any carve-outs with this one in particular that the court should be addressing? The division among the parties?
No, this is just for Myles Hunwardsen on behalf of both the United Natural Foods and WFM, the only person who drank out of the plaintiffs the 1 or 2 liter bottles.
Okay. That's what the court was checking. I thought it was only on behalf of one, and so it wasn't an issue with any division. Okay, even there was no opposition, once again, does anyone wish to be heard here in open court? This is on OST. I want to make sure everyone had full opportunity.
We're not opposing this. It's just...
Counsel, you can appreciate name, party you represent.
Your Honor, Chad, here's what we have. We have no opposition. My colleague who was reached out to understand the amounts has been dealing with a sick father that unfortunately I think has passed away. And so all I ask is that...
Condolences? Okay.
That we just have an opportunity afterwards that I can ask about the amount. That's it.
Did you let the other parties know so that if they chose to do a well-reasoned opposition, they could have?
It's in the motion itself. It's in the motion.
But since it was temporarily sealed, did the electronic version go out to the parties before it was actually temporarily electronically sealed or not? Meaning, were you e-served with it, and you may not know because you may not have been the one dealing with it?
I wasn't dealing with it. Chad Pierce. I wasn't the one dealing with it. Was my partner who is...
Okay.
It had gone out like 3 days before for that specific purpose, and then thereafter we vote to...
Is there any reason maybe we could pause for a quick second? You can step in the anteroom, tell counsel what the
offer of judgment had the amount set forth. Everybody was served the offer of judgment, so they know.
But what I understand is counsel has not been the one dealing with this case, so he may not have had an opportunity just to see it. So if nobody minds, can you either point it to him here in court or...
Your Honor, just for the record, it's on page 7 of 11 of the motion, line 18,
No, the court,
19.
okay. Thank you, Mr. Parker. The court has the benefit of it. What I just understand is there's a unique circumstance Mr. Fears was saying is that his partner was dealing with this case. He just came into the case recently, so he may not have had a chance to go through the 500 plus filings to find said number. Are you now, since you've now seen the number, are you good with it? Is there anything else the court needs to address?
Your Honor, the check fears we are good. And just for clarity, my partner, we both came in just recently in the last 10 days. It was my partner who was dealing with the offer, the good faith settlement. So.
Okay, no worries. But are you copacetic on behalf of all your clients?
Yes.
Okay. Anybody remotely? No. Okay, so the court finds it's appropriate. The factors, statutory factors, case law factors being met, the court evaluating, there wasn't any additional factors the court found to be appropriate to consider. There being no opposition, the court giving a full opportunity for anyone to address the issue. Since it was on OST, even though there was no opposition, nobody having any opposition, the court's going to find it's appropriate, both statutorily and under applicable case law, to grant a DBA Whole Food Market's motion for determination of good faith settlement on OST, which was document 506. It is so ordered. Order, please, EDCR 7.21 to the DC 31 inbox and in accordance with the administrative orders. And since this was a redacted for the specific amount, you can either, when you provide proposed order, do a redaction in the amount of with a redaction, or you can say pursuant to the CLD amount was set forth in the pleading so that we have clarity in the order. However you wish to do it, counsel, does that meet your needs, or is there anything else the court can do on behalf of your clients?
No, Your Honor. Thank you.
Thank you so very much. Okay, you're concluded. Is anybody going to require that WFM and United Natural Foods needs to stay here for the rest of the hearings because this was an oral pronouncement from the bench rather than, since it's not yet memorialized in writing under Russ versus Clark County? If anybody is going to so request, please let the court know because the court's not going to require it. Nobody here in court, nobody remotely. So you're welcome to stay, you're welcome to go, whatever you would like to do, counsel.
Thank you.
Okay, so now we're going to go to Defendant NSF International's motion for determination of good faith settlement OST, document 507. This did have redacted version 528, and motion to seal document 508. Counsel, feel free. Let's go first to your motion to seal. I don't have the same question because you filed two pleadings.
We did, Your Honor. Jonathan Fountain on behalf of NSF International. With respect to the motion to seal redact, we think the strong public policy favoring settlement here outweighs the public right of access. We're only seeking to seal two limited pieces of information, the amount of settlement and the amount of our client's insurance coverage, and there has been no opposition, so we would request that Your Honor grant the motion.
Okay. Court grants the request for the redaction. Well, first off, anybody here in court? There was no opposition, but once again, since it's OST and I've got you all here. Anybody in court want to be heard? No? Okay. Anybody remotely wish to be heard? Don't see anyone unmuting themselves? No? Okay. Court did the analysis under the applicable Supreme Court rule. The court evaluated all the factors. The court finds good cause. Defendant NSF's motion to seal, and actually this version is really redacting 2 points of information, is granted. It is so ordered. Now let's go to your motion for determination of good faith settlement. Would you like to walk through the factors under the applicable statutory provisions in case law? And if anyone wishes me to cite the cases, I will cite them again, the ones I just said a few moments ago. Not seeing anybody wants me to spend extra time on that. So, you know, the MGM factors, doctors, etc. Go ahead, please.
Certainly, Your Honor. The first factor is the amount paid in settlement. As we've argued, we feel the amount is reasonable in light of the claim that was asserted, the single negligence claim that was asserted against NSF, the available evidence, and the parties' respective assessment of the strengths and weaknesses of the claim, including the defenses that NSF raised to do the causation. Here we have a settlement between NSF and Miriam Brody. We understand that Ms. Brody is the only plaintiff making a claim against NSF in this case. Ms. Brody had made an offer of judgment, and the amount of the offer of judgment was negotiated. It was negotiated between counsel. It was a product of arm's length negotiation, and so we feel the amount paid in settlement is reasonable. With respect to the allocation of the settlement proceeds, second factor, we feel it's reasonable because the entire settlement amount will be paid to Ms. Brody. And again, Ms. Brody is the only plaintiff asserting a claim against NSF in this case. Under the third factor, the insurance policy limits, here we are within the insurance policy limits. And, the insurance is provided pursuant to a reservation of rights. So we think those two facts make settlement reasonable in light of the insurance policy limits. The fourth factor, financial condition of the parties. This was not considered and not briefed, but we feel it's reasonable because NSF is a non-profit company. And the final factor, Your Honor, the existence of collusion, fraud, or tortious conduct aimed to injure the interests of non-settling parties. There's no evidence of that, and again, the motion is unopposed.
Okay. Similar, since this also was on OST, although the court has no oppositions that were filed to the court, since I have the parties here, is going to check first in court. Does anyone wish to address anything? If so, I'll hear their reasons why. Counsel, go ahead, Mr. Fears.
I'm going to have the same question for all the settling. I don't want to interrupt the court. I can talk with them, but we don't oppose. But
Counsel, can you just show them the same numeric? Do you have it on your pleading?
I do, Your Honor.
Can you show it to counsel?
Yes.
Okay, let's pause for a quick second. Let's just get this cleaned up and taken care of for everyone.
Your Honor, again, I apologize.
No worries. By the way, that was Mr. Fears on behalf of the head instruments. Thank you. Okay. Mr. Fears, on behalf of Hannah Instruments, is there anything the court needs to address, or your clients fine?
You're fine.
Okay, appreciate it. Anybody remotely? Okay, they're not being... Okay, so the court, there being no opposition, the court giving everyone a full opportunity here in open court, since it was an OST and I had you all here. There being no opposition, the one point of clarification, we took care of that. The court finds that there is good cause under the statutory provisions as well as the applicable case law, and the court grants defendant NSF International's motion for determination of good faith settlement, OST document 507 and redacted version 528. It is so ordered. Please provide the court in accordance with EDCR 7.21 the proposed order, and to the DC 31 inbox in accordance with the administrative orders. And please just make sure you e-serve it on everyone. Wait a day or so if people wish to execute it as well. Then the next step is same thing. Counsel, since I've granted his motion, but it's an oral pronouncement from the bench. Is anyone requesting that I keep NSF here or let them choose if they wish to leave or go? If anybody's making a request that I ask them to remain, please let this court know. First here in court, nobody. Some negatory nods. How about remotely? Give you a moment to turn off mute just in case. No one. Okay, so your motions were granted. Have a great rest of your day and week. You're welcome to stay if you wish, and you're welcome to leave if you wish.
Thank you, Your Honor. I'll be going.
No worries. Have a good one. Thank you. Next, we're going to Affinity Lifestyles, DBA Real Water, and Real Water Gold Coast. Motion to associate counsel Matthew Kaufman on order shortening time, document 512. Counsel, would you like to be heard on said motion? It was unopposed. And the only question this court's going to have, and I'm going to have this question for today, and I have this question when you asked me to set another one, is will it impact the trial date in any manner or any of the deadlines?
It will not, Your Honor. Mr. Kaufman participated in the Gallagher trial. We were just seeking his admission to participate in this trial. Will actually make things a lot more expeditious for Real Water.
Okay, there was no opposition. Counsel for plaintiff, go ahead, please. Pardon?
We agree.
On behalf of plaintiffs except for Sosa. Mr. Parker, on behalf of Sosa, do you wish to be heard?
No opposition, Your Honor.
Perfect. Okay. Anybody else wish to be heard here in open court? If so, please stand up. Nobody here. Open court. I see one green box. Green light went away on the box. Okay. Anybody wish to be heard remotely? No. Okay. The court's going to find that there's good cause under Supreme Court rule, and the applicable motion is granted. So Affinity Lifestyles, DBA Real Water, and Real Water Gold Coast LLC's motion to associate counsel Matthew Kaufman on order shortening time, document 512, is granted. It is so ordered. Of course, the quicker you get the order in, the quicker, under Supreme Court rule, he can participate, right, in the case. So, one other quickly on... That takes care of that, Mr. Odou, right, on behalf of that pending motion? Is there anything else?
Your Honor.
Okay. So the next thing is, I'm just real quickly, since it came in on Veterans Day, the There's another motion to associate by Affinity DBA Real Water for Mark Love. I've got two choices. One, I can just pick a date and set it. Two, I really was going to ask you all if there's some date that I should set it, or maybe parties are going to request I address it in chambers because maybe people don't want to have another hearing. It's up to you all. So,
Judge, we haven't looked at the motion yet, but we have no opposition to it being set on order shorting time.
okay. Does somebody have a preferred date? Because where I'm seeing you all next isn't, normally I try and consolidate write these so that we don't have it kind of out there. Well, let me hear what Affinity wants a date, and let me see if anybody objects to that date. Affinity, do you have a date by which you wish it to be heard?
Whatever the court prefers, and that goes with everyone else's calendar.
And Counsel, Mr. Freeman, remember, I just need you to say, go ahead.
Yes, Eric Freeman with Real Water.
Okay, if I put it, any reason not to put it on November 28th? Is that too late, too early? Is there something going on between now and then?
That would be fine with my calendar.
Okay, so I'm putting it on November 28th, and then we will pick an opposition date for OSTs. That gives everyone enough time. I'm trying to take into account people at the Thanksgiving Center for OST times. But we'll put the hearing on the 28th, and then we'll send the schedule, and you'll get the order back with the schedule. Okay?
Will that be at 9 o'clock?
Since it's business court, it'll be 8:30. Okay? And if it's all stipulated to, and then the court would evaluate that in advance if there's said request. If there's no request, it stays on. Okay, so that is what the court understands were the shorter matters on for today. Milwaukee Instruments, Ms. Lowe, were you about to say something? Okay, no worries, I thought I saw a quarter of my eye. Okay, so now the court was going to go to the motion for partial summary judgment before I address the jury questionnaire issues, unless the parties for some reason want me to go to jury questionnaires. It seems to me it makes more sense to do the motion for partial summary judgment. So we're, right? Anybody requesting something different? No, not seeing one popping up there. Okay. Motion for partial summary judgment is document 442, a series of oppositions and erratas. Milwaukee's 475, errata 502, and Instruments 492. Real Waters 476, Joinders there too, documents 494 only to certain sections. Costco and AT&T, and Costco I'm going to need to ask a question about because of your pending status, since that was jointly filed opposition 477, index or appendices 478, Joinders there too 493, and Instruments opposition 479 with an errata 490, and then there is Scientific Instruments. I'm just reading straight from these Jointers 495, and then Plaintiffs Joint Reply 503, and then the deadline issue which was granted 504. So my first question with regards to today's motion is let's reach out to Costco in light of your pending status, and you have a joint opposition. Would you mind? I don't want you to go, if you want to go to substance, stay tuned, we'll get you to substance. If you're just going to tell the court that in light of your pending status, you don't wish to be heard, that's all. I'm trying to get a determination if I should reach out to you. Go ahead, counsel for Costco.
Thank you, Your Honor. This is Daniela LaBounty. Yes, in light of our recent settlement, we're not going to be arguing substantively the motion. With respect to Costco, the issue would be moot.
Okay. Does anyone disagree or for some reason thinks that I need to address Costco in this? If not, I'm treating it just as AT&T's and just saying the mootness on Costco. Nobody here in court, nobody remotely. Okay. So, counsel for plaintiff, that means you're up, please, with regards to your motion for partial summary judgment. Who's going to be arguing it?
Eric Pepperman for plaintiffs, Your Honor.
Thank you. And I will tell you, while I'm not requiring it, it would be helpful to the court because you've got 4 sets, right, of defendants. So I don't know if you're planning on arguing the uniqueness of each of the 4, but I might have a question if you don't. Okay.
Yes, Your Honor. The complexity of this with the different defendants is is not lost on me. I think the best way to handle it is to go one by one in the different issues that we seek to apply the doctrine of issue preclusion on. And I think that kind of divides up the different defendants under those issues. So the first issue would be the issue that real water was contaminated with hydrazine. This is at its core a product defect case. The allegation is the same in terms of the product defect and all the different coordinated actions, which there are more than 20 of. It's essentially that real water was defective and that defect was the cause of dozens and dozens of plaintiffs' individual injuries. So in terms of the defect, that looks at the product itself. It's the same issue and the same question in every single one of these cases. The same question in this case, it was the same question with the same facts, the same evidence, the same allegations that was tried in the Gallagher case, raised and tried in the Gallagher case. And that defect essentially is that real water was toxic and making people sick with liver failure. We did the discovery on that. We discovered that there was evidence of hydrazine in real water. We substantially litigated that issue. Hydrazine was tested by the FDA in the E2 concentrate used to make all of real water. Every sample of the concentrate that the FDA tested for hydrazine, they found hydrazine at significant concentrations. During the litigation, one of the defendants conducted hydrazine testing on 7 retail bottles that were sold in stores, consistent with the finding of hydrazine in the E2 concentrate used to make real water, including the retail bottles. This defense testing found hydrazine in, I guess I'll say the majority of all the retail bottles. 5 of the 7, there was hydrazine detected at levels above the reporting limit, so it was conclusive under the test. The other 2, the hydrazine, there was objective evidence in the testing that hydrazine was present, but it wasn't at the reportable limit. So there's some question of whether those tests are conclusive as to those 2 bottles. I would add that that's consistent with the other evidence. The expert evidence is that hydrazine degrades over time. By the time the retail bottles were tested, it was more than 2 years after they had been originally manufactured. And given what we know about the degradation of hydrazine, the fact that there was any hydrazine detected in these retail bottles speaks volumes to the amounts that were originally in there when they were first produced, that there was still traces of hydrazine at the reportable limits in 5 of the 7 bottles. And the 2 that the hydrazine wasn't tested at reportable limits, those were the 2 oldest bottles. So it's all consistent with the evidence that we have.
Now break it, and need to interrupt for a quick second because I got to get a clarity here. The issue that you're seeking issue preclusion on that I'm hearing you argue seems to be more narrow than what was in the pleading, right? Because the pleading seemed to focus on the liability component and rather than just the hydrazine. So can you
Yes, Your Honor.
the court, because I want to make sure everyone's on the literal same page, right? Because the opposition gave their example at Belsky versus Brody and some other things. So I want to make sure we're talking about the right issues that you're seeking preclusion on.
Yes, Your Honor. In the motion, we seek issue preclusion on liability and causation against real water and against the meter defendants. Now, those issues are separate. So we have liability against real water, which is product defect. That's the hydrazine. The second issue under that umbrella is causation. Did the hydrazine cause the individual plaintiff's injuries? Mm-hmm. Then we have issue of liability of the defective meter. and we have warning causation. The liability is failure to warn, that the meter companies failed to warn and the meter was defective for failure to warn. Then we have warning causation. That's would the people who would have acted on the warning, or would the people who the warning would have been directed to, would they have acted upon it? That's the causation issue under the warning. And then we have the breach of implied warranty. So because they're separate against different defendants, I'm addressing them one by one. So the first one I'm going to address is product defect of real water. Then I'll address causation of real water. Then I'll address the product defect of the meter, and then I'll address warning causation, and then last I'll address breach of implied warranty. So I'm just breaking it down into those separate individual issues, because ultimately, Your Honor, in applying issue preclusion, it's whether the factors apply to each of these individual issues, and if they do, it's still a matter of this court's discretion of whether you should apply issue preclusion. So I think taking them one by one in these more narrow issues under the broader umbrella will help organize the arguments and help let the defendants respond to the issues that apply only to them, and then will help Your Honor exercise its discretion in deciding whether it applies issue preclusion to all these issues or a subset or none. So the first issue, like I said, was the issue of defect, product defect in the water, and that's hydrazine. And I think this is the easiest one, because this one, we litigated it. Every piece of evidence shows that hydrazine was in this water. All the experts agree that it was being manufactured as part of the real water manufacturing product. It was getting dumped into the finished product that was being consumed by the public. And Real Water conceded this at the last trial. And I don't know if there's really a basis for them not to concede it in this case.
But isn't their argument that it wasn't necessarily litigated, and so therefore it doesn't meet the prongs for issue preclusion?
Yes, Your Honor, that's one of the arguments that they make, is they say, well, we conceded this, so therefore it wasn't actually and necessarily litigated. And so I'm not even sure that they're still going to go with that, because really what this comes down to is, how are they going to admit that hydrazine was, all over this product, that it was in the water, it made people sick, and then come into this court and say, well, actually, no, there was no hydrazine in the water. It doesn't make much practical sense. But in the terms of the legal issue of whether it was actually and necessarily litigated, they kind of cite this broad brush rule that, because we stipulated it, we can't meet that factor of issue preclusion. Well, that's not the law. What the law says on whether something's actually and necessarily litigated, was it raised in the prior lawsuit? Was it an issue that was raised? And I think absolutely yes. There's no reasonable dispute that it was actually raised, and this was an issue. It was the subject of discovery, subject of expert witnesses. That's actually litigated. Then you have necessarily litigated. Necessarily litigated means, was it a necessary part of the judgment? And so the answer in this case, was it a necessarily litigated in the Gallagher case, is of course it was. It was their stipulation, their acknowledgement of it, this fact that hydrazine was in the water, that was necessarily part of the judgment. There wouldn't be an award of compensatory damages against Real Water if it wasn't defective, if it didn't have hydrazine in it. There wouldn't be an award of punitive damages of $200 million if there wasn't hydrazine in the water. This fact, this issue of hydrazine being in the water, that was an absolute foundation of the jury's verdict and the judgment, including the award of compensatory and punitive damages. So the issue of was it actually necessarily litigated is a simple yes, because it was raised, it was a it was a subject of extensive litigation, and it was necessary part of the Gallagher verdict and judgment. But I'll let them raise that issue if they're still raising it. But I think in terms of the factors of issue preclusion on this first issue, all of them are satisfied. It's identical issue. It was actually necessarily litigated. It was part of a final judgment, a jury verdict, which is sufficient for the application of issue preclusion, and it was against the same parties. In terms of the court's discretion, would it be unfair to Real Water to apply issue preclusion on this first issue? Your Honor, I would submit that it would be unfair not to apply issue preclusion because they admitted, they conceded it, they litigated this, and they said, okay, there's no defense to this. The hydrazine's in the water. To let them come in and prolong a trial by several weeks at great cost and great expense and risk an inconsistent judgment by letting them backtrack and renege on something that they've already admitted to, I think that would be unfair. So when we're talking about the application of issue preclusion on this first issue, I think that it's unquestionably applicable and appropriate in this case. And unless Your Honor has any other questions on that one, I'll move to the second issue.
No, go ahead, please. Thank you.
Second issue is causation. This issue is different than the first issue, I'll concede, because there are elements that are individual to each plaintiff. Each plaintiff has to prove causation, that their injury was caused by hydrazine in Real Water and not something else. In the oppositions, what they say in dispute to this issue is, well, because there are potential differences, you can't apply the issue preclusion as to causation. And the problem there is when they get into the details, they only reference Miriam Brody. They only say, well, Miriam Brody, had this medication and it could have been something else. It wasn't, she didn't really have the liver failure injury that the other plaintiffs had. And there are alternative causation possibilities with respect to her. For the purposes of the hearing, I'm not going to dispute that. I think we can set Miriam Brody aside and say causation as to Miss Brody, that's an individual issue that we won't seek to apply issue preclusion on. I think there are differences there that preclude it. The other four, however, there are no meaningful differences that have been identified. These are plaintiffs that were in the exact same time period, within days or weeks of the exact outbreaks that were litigated in the Gallagher case. When this water's being contaminated with hydrazine and sold to the public, it's not in one bottle. It's in a batch of bottles that goes out. And so the three of the plaintiffs were all part of the 2020 super bad outbreak, what we call the super bad outbreak.
Hold on a second. Please be respectful. Please mute yourself. You're more than welcome to listen. But we do have somebody speaking. So please, we don't want to hear if the microphone's going off or whatever you're doing. Please mute yourself. Okay, Counsel, would you like to continue? Go ahead, please.
Yes,
okay.
Thank you, Your Honor.
Three were in the 2020. Go ahead.
Three were in the 2020 period. And I would note that the meter defendant's medical expert, Dr. Kenner, in his deposition, he concedes that Real Water was the cause of these three individuals' liver injuries. So in terms of any potential differences that may distinguish these four individuals, Hunwardsen, Sosa, Jasmine Schaefer, and Tina Hartshorn, while their may be differences that impact the court's analysis in applying issue preclusion. They have not raised any of those differences in the opposition papers or to the court. And in fact, they have not asserted any alternative causation theories that would give this court any reason not to apply issue preclusion, or in the alternative, at least an ability for us to address them to narrow the issues elsewhere. So with respect to Ms. Brody, we would concede that the factors of issue preclusion would not fully apply to her on the causation issue alone, and that we would exempt her from this. But we believe that there's nothing before the court that differentiates the causation issues that were tried in Gallagher with respect to any of the other four plaintiffs in the case. And again, we think that if they meet issue preclusion on causation, meets all four of the five-star capital factors, and that it's fair and reasonable under the Park Lane factors to apply issue preclusion, because it would further and advance the goals of issue preclusion, which is to avoid inconsistent judgments, support finality, judicial economy, saving time, money, expenses that are associated with relitigating the exact same issues that have already been decided. So unless the court has any other questions on this issue, I go to the next one.
Okay. So now you're going to the meter?
Yes, Your Honor. This next one is the meter liability in
Are you grouping them together, or are you doing them separately?
This issue is meter failure to warn and warning causation. Now, remember in the Rivera v. Philip Morris case, that talks about a failure to warn claim. And it's the same product defect claim that we have to prove, that the product was defective, that the defect was the cause of the individual, a legal cause, substantial factor in leading to the plaintiff's individual injury or harm, and damages, of course. But there's an additional warning causation when you talk about failure to warn, because you have to show that in addition to the the harm caused by the hydrazine getting in the water and causing these plaintiff's injuries, you have to additionally show that if there was an adequate warning, that warning would have been acted upon and made a difference. In the Rivera case, they say the person who's receiving the warning would have had to act upon the warning, heed the warning, or change the take action to avoid the injury. Essentially, act upon the warning is what we included in the verdict form in the Gallagher case. And so I think that is essentially one issue. And so that issue is essentially, all right, what was the warnings that they provided with the meter to Real Water for the purposes of what Real Water was using it to make this alkaline water? Were those adequate? And if not, if they would have been given an adequate warning, would Real Water have acted upon that warning? And so those issues in this case are identical, both issues, because the adequacy of the warning is, well, okay, did you communicate the risk? Did you identify the hazard? The jury in Gallagher was instructed on the standard warnings instructions. This is what an adequate warning is. Did this meter have an adequate warning? And when you talk about who would have acted upon the warning, this is people at Real Water. This is the people at Real Water using the meter. And so all of those issues, all of the evidence, all of the facts, they're all the identical issues, facts, and evidence that were at issue in the Gallagher case. None of that is going to change in any other of the coordinated cases based on the change in the identity of the individual plaintiffs. Because who the plaintiffs are, they have nothing to do with whether the meter companies gave Real Water an adequate warning or whether Real Water would have acted upon that warning. All those issues and evidence, those are frozen in time based on the exact same evidence that was presented in the Gallagher case. And so when we look at the 4 factors of issue preclusion, they're the identical issues. They don't change based on the individual plaintiffs. It's not like the causation issue we just discussed. That's individual personal injury causation. This is warnings causation. That has to do with Real Water, and those actors are all the same. Same testimony, same depositions that would be played, same witnesses that would be called, everything. Same jury instructions, same issues with the adequacy of the warning.
Wait, same jury instructions. Isn't there a distinction between Milwaukee and Hannah, though? One went to a jury, one did not.
Well, Your Honor, no, there is no difference, because we're not talking about what did Milwaukee do, what did Hannah do. We're talking about the meter. Is the meter, a meter have adequate warnings? And that's the product. The focus is on the product, not Hannah or Milwaukee.
Counsel, the reason why the court's asking the question, right, wasn't it Hannah was out through motion practice and Milwaukee went to a jury verdict?
Well,
yes or no?
Hannah wasn't out. During the trial, at the end of the trial, Hannah confessed that there had been testing that they had done prior to the trial that had never been disclosed. And that became a big issue because during the trial, a big part of Hannah's defense was to suggest that there was this testing out there that somehow showed that the warnings on the meter were adequate and sufficient. And so as a sanction, right before the case was given to the jury, the court sanctioned Hannah and said, look, based on this misconduct, we're going to enter liability for you and let the jury decide on what the damages are going to be. But that was only as to Hannah. The questions that we seek issue preclusion on, the adequacy of the warnings and whether the warning would have been an adequate warning would have been acted upon, those still went to the jury as to Milwaukee, who was not sanctioned. And that was by design. Your Honor, we could have argued for the same sanction against Milwaukee because they're sister companies. The president of Milwaukee is the vice president of operations for Hannah. They're all owned by the same companies, these SID entities. So they're really one and the same company. They manufacture the meter and through a bunch of other sister companies, and then it's distributed and sold through the United States through Hannah Instruments in Milwaukee. And so they were sued for strict liability as part of the chain of distribution of this meter. And so the issues that went to the jury all were the same as the issues are here. Was the meter defective due to inadequate warnings? Doesn't matter if it was Hannah who sold it or Milwaukee who sold it. They're just distributors who passed it along. And so the determination that was made, that's in the judgment, was that the warnings with the MW500 meter were inadequate. That was the issue that was decided. That's the issue in this case. Are the warnings adequate? And under the doctrine of issue preclusion, we submit that partial summary judgment on that issue is appropriate here because we've already tried and litigated the exact same issue. Milwaukee put on their defense. Hannah put on the defense for the entire trial. All the evidence on this issue was called. All the experts were called. Everything was litigated with respect to the adequacy of these warnings, and it was submitted to the jury who decided they were inadequate. So under the doctrine of issue preclusion, we think that the meter company should be prohibited from relitigating these exact issues based on the exact facts, based on the exact evidence, because it's already been litigated and decided that the warnings were inadequate and that the same people at Real Water would have acted upon an adequate warning. Those issues have been litigated and decided. Issue preclusion applies. We think it is appropriate under the Park Lane factors to apply issue preclusion here because this was an extensive part of the trial. I mean, it was the majority of the trial, in fact, litigating this issue of the adequacy of the warnings and the warning causation, whether it would have been acted upon. So we're talking about extensive time, extensive expenses, judicial resources associated with relitigating an issue that has been fully litigated and decided by a jury already. And so we think under Nevada law and under sound judicial discretion and in advance of the policies underlying the very purpose of the doctrine of issue preclusion, we think that issue preclusion on the inadequate warnings and warning causation against the meter companies in this case should be entered. And then finally, unless Your Honor has any other questions, I'll move to the breach of implied warranty. The breach of implied warranty is only against Milwaukee. This issue was fully litigated and decided in the Gallagher trial. The district court on summary judgment said, yes, undisputed, no question of fact that one of the purposes of this MW500 meter was to take negative ORP readings while making alkaline water. The only question for the jury is, was it fit for that particular purpose? The jury was instructed on that issue. They determined it. They decided expressly in the verdict form, no, this meter was not fit for the particular purpose of taking negative ORP readings while making alkaline water, and that the lack of fitness was a substantial factor in leading to the injuries in this case. The argument raised by Milwaukee and the opposition, that they spend an inordinate amount of time basically saying, well, this breach of implied warranty claim wasn't specifically spelled out in the Gallagher complaint. And it was only kind of came about at the end, and it wasn't therefore fully litigated or fairly litigated in the prior Gallagher proceeding. So that's all really a red herring. Ultimately, it wasn't the cause of action wasn't spelled out specifically in the complaint. We litigated that issue as part of the summary judgment. And they said, well, hey, you didn't allege this claim. And we said, well, we did allege it. It's notice pleading. Maybe we didn't spell it out exactly, but that issue was alleged. All the claims, the facts were alleged in the complaint. Just because we didn't title it correctly or title it specifically, that doesn't mean you didn't have fair notice of the claim. Plus, all the evidence is the same. We're seeking summary judgment on this well in advance of trial, and the district court, agreed that it was sufficiently noticed in the complaint, granted summary judgment, partial summary judgment as to the particular purpose issue, and then the rest went to the jury. But ultimately, that doesn't matter because we did specifically allege it in this case and long ago. So there's no question that of what their complaints were in the other case that, oh, we didn't have notice of this claim. They had notice. It was specifically alleged against Milwaukee in this complaint since, I think, March. And so, what we're looking at in terms of issue preclusion is, was the issue that's raised in this case previously decided in the Gallagher case? And the answer is yes, because this case, there's no question that it raises the issue of breach of implied warranty here. And there's no question that it was previously decided in the Gallagher case. Now, they may not have liked that it was decided in the Gallagher case, but it was. That's all that matters, is it was litigated at trial, it was submitted to the jury, and it was decided. And it's the same issue raised here. So on that basis, we think that Milwaukee's, the large part of its opposition is based on a red herring that really doesn't affect the application of issue preclusion in this case.
So which or both prongs are you seeking issue preclusion against Milwaukee on the breach of implied warranty? Part for summary judgment, or the part in Gallagher that went to a jury, or both? It's unclear what you're saying. I understand your argument why it should.
Yes, Your Honor. Okay. Both. The issue of really the claim of breach of implied warranty in this case, which is the one of the particular purposes of the meter was to take negative ORT readings while making alkaline water, that the meter was not fit for this particular purpose, and that this was a substantial factor in the leading to the outbreak, the injuries as part of the outbreaks. And so those issues were decided in Gallagher by the summary judgment motion, by the summary judgment order, and by the jury verdict finding that it wasn't fit for a particular purpose and that it was a substantial factor in leading to the outbreaks. And so it was essentially those claims. In sum, we think issue preclusion is appropriate as to the issues of liability and causation on plaintiff's product defect claims against Real Water, that the water was defective due to hydrazine contamination, that hydrazine was the cause of the plaintiff's injuries, liver injuries, except Brody, the four excluding Brody, and that damages will be determined at trial. And issue preclusion as liability and causation as to the meter defendants on the failure to warn claims related to the meter, that the meter had inadequate warnings, that the warnings would have been acted upon, and leaving the issue of damages for trial, and liability and causation for breach of implied warranty against Milwaukee, that the meter was unfit for the particular purpose of taking negative ORT readings while making alkaline water, and that this was a substantial factor in causing the outbreaks, except Brody, and leaving the issue of compensatory damages for trial. And I would note that our motion does not affect Terrible Herbst, who's the remaining retail defendant here. We're not asking that Terrible Herbst be precluded from relitigating any issue. Really, all they have is the causation of the retail bottle, which is what we call the amount of usage defense, and nothing in the order that we're requesting, nothing in applying issue preclusion to these issues that were previously litigated and deciding is going to take that defense away from Terrible Herbst. So they, along with Costco, who's no longer interested, filed an extensive opposition. I don't see how that has any application here. They aren't losing anything that they otherwise would have had but for this ruling. So on those issues that I just described, we'd ask partial summary judgment based on the doctrine of issue preclusion.
Okay, appreciate it. Thank you. Okay, seems to me that, Affinity Lifestyle, who goes next? Do your opposition.
Good morning, Your Honor. I want to make a couple, I think, really important points to start with. Liability and causation in the Gallagher case were stipulated to. It was not, liability and causation were not established by judicial resolution. The plaintiffs are all different. Each one is unique. And that's why with strict liability cases, plaintiffs have the burden to show that a product was defective and that that product was a substantial factor in causing their injury, not someone else's injury, not an injury to someone in another case. And that's why when defending liability and causation, defendants make the decisions based on the case, facts, and specific plaintiffs. Here this morning, Real Water argued that, well, they stipulated to liability causation in the other case. They want to backtrack now?
I think you mean plaintiffs argued, right?
I'm sorry. What?
Not Real Water argued?
You're
no worries.
Thank you.
I
Plaintiffs
just
argued.
wanted to clarify that I'm hearing.
Yes, yeah.
Okay, no worries. Go ahead.
Plaintiffs just argued that Real Water stipulated to liability and causation in the other case, and now they're trying to backtrack, and they shouldn't be able to do that. Well, this motion isn't about what Real Water would stipulate to or not stipulate to. This is a motion on issue preclusion, which is really important. Nevada has factors set to how that is applied. And in this case, there are 4 factors, and only three of them fail. Issues in the prior case must be identical. They are not identical. The issue must be ruled on by the merits, and that the issue must be actually and necessarily litigated. The only one that doesn't apply, we concede, is that the party against who the judgment is asserted is the same. Real Water was Real Water and Gallagher, and Real Water is in this case as well. So the 3 factors are the ones that are important here. Again, issues being identical, I think they're all different plaintiffs. They're all different people. Each one has to show that a product was defective and that it was a substantial factor in causing their injury. The plaintiffs were hospitalized in different times. They had different diagnoses, different treatment, different medical histories. Each one is different. And the cases that were cited by plaintiff all dealt with the same plaintiff with the same incident. And here they are all different, and therefore they're not identical. Gallagher was not determined on the merits. Liability and causation came to by a stipulation. There was no evidence presented on liability and causation. There wasn't any examination of witnesses or defenses as to liability and causation whatsoever. It was the case, facts, and plaintiffs were carefully considered, and they came to a determination that based on those specific facts, in this case, that they would stipulate to liability and causation. Real Water should have the opportunity to make that same consideration in this case and not have it thrown upon them by issue preclusion. Again, there wasn't any specific court finding in Gallagher, and there was not any verdict against Real Water as to liability and causation. The final factor is that the liability and causation were not actually litigated in Gallagher. Again, specific facts, different plaintiffs. Collateral estoppel should not be based on stipulated facts, especially when there was no intent that it would go beyond that case that they were stipulated in. We cited a number of cases in our opposition that held that facts stipulated to in a prior case and facts that were not established by judicial resolution were not actually litigated. And that is why defendant Real Water should have the opportunity to make this careful evaluation as far as liability and causation, and not have it be forced upon them, by this motion. To apply issue preclusion to these different plaintiffs in different case would be unfair and it's contrary to public policy. And if you have any questions or?
I do. Okay. Counsel for plaintiff was asserting that there was conceded that hydrazine was in the water, and that how could your client say in this second case that hydrazine was not in the water at all the times, and so that the court should, he broke it, right? That prong of the liability aspect. So how do you address that issue?
Well, I think it's.
I understand your concept. Okay, your nice little boxy chart. Okay, really nice chart, right? Your Brody versus Belsky. Okay, nice alliteration, nice comparison. I'm not taking a position on it. I'm just saying nice comparison, right? But if you go down to the concept, and I will use hydrazine. We're not using term rocket fuel. Today, there's no advanced ruling on anything. That's just it's hydrazine today, right? Hydrazine in the water. How does one say that would be different for this case?
I think it comes more down to.
Is there something in this case? Thank you for all the briefing. Okay, which, by the way, the court does prefer jump drives. It saves you all paper and stuff, and it's just easier than lugging these home every night. But in any event, are you going to come to trial and say there wasn't hydrazine in the water?
And when it comes down to it, we're not saying we're going to fight liability in this case. We're just saying that we should have the opportunity to evaluate it instead of it being forced upon us by an issue of preclusion, which it doesn't meet the factors. We may ultimately, likely, admit to liability, but it should be the defendant's decision, because it's important that when they're making these evaluations as far as liability and causation.
But don't I have to do that under Park Lane? Let's circle back to the question, right? And I get it. Sometimes people do right up to the wire, but what I'm trying to get a better understanding, right, is parsed out with regards to the first concept, right? The focusing purely on the liability prong, your client, and the concept of hydrazine in the water. Not going to the causation yet, but fully understand the not litigated, okay? 5-star factor's been done this a long time. But when I was reading through everything, I didn't see any disagreement that there wasn't hydrazine in the water. Okay, I appreciate that there's the two lines and a person that got hired, and there's the issues about whether or not the person was qualified, not qualified. Some went to a different state, some stayed, okay, all that, right? But you parse it down to, is there anything presented in opposition to their motion for partial summary judgment that would say that anybody's contending there was not hydrazine in the water? And I'm not asking you to speak on behalf of Hannah in Milwaukee. I'm asking for your clients. And I'm about to find out if Real Water, Tennessee might have a different view, although I didn't see pleading. Okay, but I'm just saying, for your clients, don't I have to decide that as part of their issue preclusion? There's not like a Rule 56F component that you said here, right? Yeah. Okay. Nobody went there.
Well, I'll say hydrazine was in the water.
Okay, I wasn't asking you to I was trying to carefully couch my question in is somebody going to potentially say something at trial? I wasn't asking for admissions on the record, okay? But, so then, what? Okay, so then what from an issue, and I appreciate the analysis before this court is issue preclusion, right? It's not a motion, okay? The way it's phrased is an issue preclusion concept, right? Why wouldn't the court address that today on issue preclusion? That first problem, I'm not going to the causation problem, I'm purely focused on the liability problem.
As far as the liability, it's of our opinion that it didn't meet the 4 factors, and we believe the defendant should make those decisions as they evaluate their case while discovery is still going on. But again, the main focus of our opposition was the causation aspect of it.
We all understand it's mid-November and the trial starts not on Friday, it starts on the Tuesday after, right? So.
Discovery's closed, Your Honor. If that's the
I believe.
Yeah, no, I'm sorry, I was pausing only because, since I remember a long time ago, I inadvertently said on the 12th instead of the 16th. So now every time I'm checking the calendar before I say it again, it's Tuesday the 16th. Okay. So given where the case is now, realistically, why wouldn't the court rule today? Is it the technical argument that it actually wasn't litigated because it was stipulated to? Is that where's going? I'm not trying to put you on the spot, but I'm trying to walk through each of these analyses, walk through everything.
Well, the intent of that stipulation didn't apply to this case or any other cases, and so it wasn't. I mean, I'm just thinking of the ramifications of coming to stipulations in a case. People may be leery with saying, okay, well, is this going to affect me sometime else unintentionally?
No. I mean, like I said, I get all the pure procedural arguments. I get them. I should say more judicial. I understand and fully comprehend the procedural arguments. And that's the focus. Is that correct? Then it's the procedural aspect?
Yes.
Because tomorrow I might get a stipulation that says you stick to liability. I'm not saying I will, but
yeah, exactly. And I'm making my arguments here, and it's your ultimate decision.
No worries. That was my only question. I appreciate it. Okay, does that take care of your argument? Well, now I was going to go to Real Water of Tennessee. So we keep the Real Waters, and then I'll go to the meters.
Your Honor, that's fine if the court wants to proceed in that matter, but I just remind Your Honor.
We need you up in the back.
We need you near a microphone.
Good morning, Your Honor. Robert Schumacher for the third-party defendant, Real Water of Tennessee, LLC. And I just was going to bring to the court's attention the fact that Real Water of Tennessee is not a defendant.
I know you're a third party.
Okay. All right.
I might be familiar a little bit with the caption.
Okay.
Trial coming up in January, but
okay, so
that's not the issue. I was really trying to focus some of the concepts, right? If you don't want to be heard now, I'll do the meter defendants. I mean, honestly, I just was trying to do it in a way that made sense to this court versus going in the procedural posture of the third parties, because it seemed to me that you might have some agreements, possibly differences of viewpoints, but I don't care. I'll do meter defendants next.
Your Honor,
I'll do ETT next. I don't really care.
We're prepared to make our points now.
Okay, go ahead.
The court is somewhat prescient in that regard. Simply, Real Water of Tennessee, we've heard from plaintiffs in arguing this motion that the real water. Well, it's important to note that the real water products that are at issue were manufactured at different locations in different states.
At different times.
And at different times and different sizes, shipped to different areas, et cetera, et cetera, et cetera. So any ruling by the court on plaintiff's motion should take into account that Real Water of Tennessee did not supply water to Nevada, did not supply water to any of the plaintiffs. So the ruling should reflect that Real Water, that there is no binding effect on Real Water of Tennessee. It's that simple.
Anything? Okay, thank you. Okay, now let's go to meter defendants. Who's gone first? Ms. Lowell? Go ahead, Milwaukee. And you're going to break it out to the two concepts as plaintiff did? Since you've got your own special, well, however you're going to do
I
it, go
kind of
ahead.
have my own outline.
Sure, no
I'll
worries.
do, it follows what I did in the opposition, which was very long, and I apologize. I felt it was necessary.
No worries, no apologies necessary.
So, as a preliminary matter, we would contend that the issue of standing of the plaintiffs is individual to each standing. So whatever determination was made in the Gallagher trial should not, even if the court applies issue preclusion here, we should still be allowed to argue standing on all claims, which we did in our motion for summary judgment, which was filed to be heard in the normal course. And in addition, we would note that plaintiffs have three claims here. They have a claim for unreasonably dangerous. They have a claim for inadequate warning. They have a claim for breach of implied warranty. They're asking for summary judgment on two of those claims. So without some additional event happening, that third claim would still be out there, and we would be able to dispute causation and liability on that claim. So then I think the best thing is to acknowledge we all agree on this whole framework, the 5-star framework with the 4 elements, same defendant, same identical issue, not same, identical, final and on the merits, and necessarily and actually litigated. There is a second prong of the analysis that would be the Parkland factors when you're applying non-mutual offensive issue preclusion. That also includes a list of 4 factors, but that's a non-exclusive list. The court is free to, when it's exercising its discretion, it's free to look at anything that it feels would cause unfairness to the defendant. The analysis, the critical point in that Parkland analysis is not would it be fair to all? The question is, would it be fair to defendant? So then the very long statement of facts, which includes something about breach of implied warranty, I'm going to go through it first, and it dealt with 4 topics. And each of those topics was included for a reason, because it goes to one of the 4 factors in the 5-star analysis, or it goes to one of the factors in the Parkland analysis. So the first topic that dealt with the plaintiff's counsel's use of NRS 16025 in order to move the trial dates on the many cases that have been filed regarding real water around. I note that this trial was set first on October 19th by this court. At that time, plaintiff, they asked, I think, for a quick trial, but they didn't raise Miriam Brody's age. Miriam Brody is over 80 and was over 80 at the time that this court set the trial in January. 9 days later, after this court set the Hunwardsen trial on January 16th, the same plaintiff's law firm filed in the Gallagher case a motion for preferential trial setting, asking for the Gallagher trial to be set first. And they didn't say first, they just said quickly. And the plaintiff in that case, who met the requirements of NRS 16025, was Yvonne Arnone. She was, I believe, 75 at the time, 7 years younger than Miriam Brody. And I also, in that section, we discussed in a footnote, we discussed the Kava case, which is one of the latest filed. I think it's in Department 31. It was filed in January of 2023. It's trial in April based on a motion under NRS 16.025. And it's, there are a lot of other cases that were filed earlier that will be going to trial later. In our view, this goes to the Parkland factor, which I didn't enumerate before. Shall I go over them now? The 4 factors in Parkland, we are discarding and not discussing the inconsistent rulings. There are none. We're discarding and not discussing the Parkland factor of incentive to defend. Milwaukee did have an incentive to defend in the Gallagher trial, so we're not. But the two factors we are discussing are the a wait and see attitude adopted by plaintiffs, and what is the other one? I'm sorry, I'll have to come back to it.
No worries.
So the use of NRS 16025, we believe, goes to the Park Lane factor of wait and see. Plaintiffs taking the Hunwardsen plaintiffs took a wait and see attitude and wanted the Gallagher trial to go first, so that they could come to you and ask you not to decide a bunch of issues and tell you, oh, you can shorten your trial and you don't need to. So, it's all been decided. The second topic that was discussed in the statement of facts was the convoluted events leading up to the inclusion of the breach of implied warranty for a fitness for a particular purpose. It was long. I included it because I think it has to do with the court's examination of the fourth Park Lane factor is procedural opportunities, which might be present in the second case, which were not present in the first case. That was kind of to discuss the procedure of adding this claim. And it was also, if you look at the jury instructions, the final determination that I come to is the elements of the claim that plaintiffs brought in the Gallagher case for breach of implied warranty of fitness for a particular purpose are not the same as the elements that are articulated in NRS 104-2315, which is the UCC claim for breach of implied warranty of fitness for a particular purpose. So because those elements are not the same, it is not identical to the issue that was decided, that should be decided in this case. The third topic that was discussed in the opposition had to do with the court's decision there to provide the jury with instructions on superseding cause, and the court's decision to eliminate or exclude the testimony of an expert who would have discussed superseding cause and supported our affirmative defense of superseding cause. We included that essentially under the Park Lane element of procedural opportunities. We can't predict what would happen here, but if we were to have the opportunity to argue superseding cause, that could result in a different outcome. In addition, I'll note that the superseding cause, a lot of the arguments that are all discussed in the attached exhibits of days and days of trial, but I used excerpts, not the entire exhibit, entire trial, had to do with the stipulation between Real Water and plaintiffs. That stipulation was announced on August 30th to all, but there was no discussion at that time of the fact that plaintiff was dropping two claims that they had asserted against Real Water, claims for negligence and negligence per se. So as we're going through trial, what happened is Real Water started to take the position, oh, you can't argue superseding cause because these claims have been dropped, these claims for negligence. And the judge agreed with them. And then on October 4th, which was just before the jury verdict came in, there was a stipulation entered to dismiss the claim for negligence against Real Water and the claim for negligence per se against Real Water. However, it was not signed by Milwaukee. It was not signed by Hannah, which under Rule 41 makes it ineffective for so the superseding cause, it goes to procedural opportunities, but it also goes to the 5-star element of finality, because there's these claims kind of floating out there that were not properly dismissed. And I just looked at the judgment that was recently filed. I don't think they're included on that either. So the fourth topic in the statement of facts had to do with the sanction that was entered against Hannah. I understand plaintiffs are saying, oh, well, you know, there are all these jury instructions that said you will find liability for Milwaukee, et cetera, et cetera. However, and I agree, there are, and the jury would have had to disregard those in order to just decide, oh, because the court found Hannah liable, Milwaukee must be liable. But there are other instructions, instruction 29 and 31, which instruct the jury if Hannah's liable, then Milwaukee's liable. So my point is, well, we don't know which instructions the jury ignored, but there are conflicting jury instructions in there, which mean that finding was not made. We can't assume it was made on the merits, and all inferences should be made in favor of Milwaukee. So given the fact that we can't say finally what the jury decided, and I think we should infer that they did take into account the court's finding that Hannah was liable, and they did not actually decide the issue of, I think this is the warnings issue, adequate warnings against Milwaukee on the merits. In addition, I'll note that the affidavit of Robert Robbins says he spoke with the jurors, and his understanding was that at least some of them were like, oh yeah, well, you know, it's one product. You can't have one person liable and the other person not, because that's what we were told. They're the same. So I think that comes to the end of the topic. So now we get to the analysis, and I'll try and, do you have any questions? Have I gone too fast?
No, I'm good. Thank you so much.
All right. So we would, for all of the findings that they've asked for, we would agree that it's the same defendant. On the issues, I don't think the closest one that comes to an identical issue would be the adequate warnings. I think that, you know, on that I would rely on it wasn't decided on the merits, and it's not final. And then the issue, and causation. There seems to be kind of a flip-flop going on here. This is a motion for summary for issue preclusion. It's plaintiff's burden to show are identical. It's not my burden to come forward with evidence to show that they're not identical. These are different plaintiffs. There's no evidence to show they went to the same hospital. The dates are close, but they went to different hospitals, they had different treatments, they have different medical records. I don't know how you can just stand up and say, oh, well, it was the defendants, you know, it was required by the defense to come in and say, oh, these are not the same. They're clearly not the same. They're different plaintiffs. So that takes care of the identical issue. Going on to finality. In addition to the two kind of claims that are hanging out against Real Water, there are also the third-party claims. Those have always been in the case. They were discussed before the jury verdict. We provided a copy of plaintiff's second amended third-party. Plaintiffs, I guess, have now stepped into the shoes of the entity that was bringing third-party claims, and they have now brought, you know, there are multiple third-party claims that have not been adjudicated in the Gallagher case. And under Rule 54B, that is simply not final. I didn't include this in my brief, but I will. I found a case last night. Definition of final judgment is an order that disposes of all issues and leaves nothing for future consideration. Warren versus 8th Judicial District Court, 134, Nevada 649, the 2018 case. And necessarily litigated. I think the one that applies to would be the issues and the issues on the breach of implied warranty. So then we move to the park-lane factors, and I would just reiterate the two ones that we would rely on primarily would be the park-lane factor regarding a wait-and-see attitude. It certainly would be unusual to, given the fact that the plaintiff's counsel deliberately caused Gallagher to go before this case when this case was actually set first, I think creates an inference that it would be unfair to defendants to apply issue preclusion. In addition, I provided some examples of procedural opportunities that I think would make a difference in this proceeding.
I appreciate it. Thanks so much. Okay. Who's taking it for Hannah?